Venue. Venue involves the determination of the judicial districts in which a plaintiff may bring a suit. Determining proper venue. For most actions, venue is proper where A, any defendant resides. So in any district where any defendant resides, provided all defendants also reside in the same state in which the district is located. B, location of the claim or property. So in any district in which a substantial part of the claim arises, or in which a substantial part of the property that is subject to the action is situated. Or C, the defendant subject to plaintiff fallback if no district can satisfy A or B above. Venue is proper in any district in which any defendant is subject to the plaintiff. So residency for venue purposes. People is determined by the domicile. Corporations reside in any state where they are subject to personal jurisdiction. So in a state with more than one district, it is occasionally also necessary to determine in which districts a corporation resides. A corporation resides in a district if its contacts would be sufficient to subject it to PJ if that district were a state. So for non-corporate businesses, residents of all the districts in which it was subject to personal jurisdiction when an action commenced, so this is a broader standard than the principal place of business. In unincorporated association, the residency is determined by the location of the association itself, not by individual members. So in a venue transfer, a case can be transferred from one federal district to another in which the case could have been filed, or one to which all parties consent. So a party may transfer venue, but a court may refuse if the original venue is proper. Federal law governs venue transfer. So a venue in an original district is proper. A court may order transfer based on the interest of justice, convenience of parties and witnesses. A court's discretion is based on public factors. So what law applies, which community should be burdened by the jury service, and private factors. So the convenience, such as the location of evidence and the witnesses. So the venue in original district is improper if a court may transfer in the interest of justice or dismiss the case. Choice of law. Transferee court applies choice of law rules of the original court regardless of which party sought the transfer. An exception is that transferee court will apply its own laws if original venue was improper. The forum selection clause, cases must be transferred to the indicated federal district unless the public factors present a compelling reason not to transfer. Forum nonconvenience, when there is more appropriate forum for the litigation, but the case cannot be transferred there, a court may dismiss the action pursuant to the doctrine of forum nonconvenience. Adequacy of the alternative. Because a dismissal is consequential, courts will not grant forum nonconvenience without finding that there is an adequate alternative forum. When adequacy is in doubt, a court may stay the proceedings rather than dismiss so that it can resume litigation if necessary. Factors are that a court evaluates based on the same public and private factors as for venue transfer, so convenience, applicable laws, etc. This requires a strong showing of public and private interest to dismiss or stay. Service of process. Service of process is the delivery to the defendant by the plaintiff of the summons and complaints which satisfies notice requirements for personal jurisdiction. Subsequent papers filed with the court motions and answers do not require formal service. So service requirements: defendant must be served with 1, a summons, which is a formal notice of the suit, must be signed by the court clerk to tell defendant when and where to appear and identify the court, parties, plaintiff's attorney, and 2, a copy of the complaint. Timing: service must be within 90 days of filing the case. If not satisfied, case is dismissed without prejudice unless plaintiff shows good cause for delay. Who may serve? Any non-party aged 18 or older. Methods of service and waiver of service. Most common methods of service of process are 1, personal service, 2, substituted service, left with a third party at the defendant's usual abode. Third party must be legally competent, reside at the abode. 3, service upon defendant's authorized agent. Receipt of service must be within the scope of agency. 4, any method of permitted under the state law. This is allowed if state is A, where federal court sits, or B, where service is effected or where service occurs. Waiver of service. Plaintiff may request that defendant waive service by mailing the defendant the complaint and formal request to waive service. If defendant denies request or fails to respond, plaintiff must serve through another acceptable method. Defendant is then obligated to pay for the cost of service. If defendant agrees to waive service, defendant extends her time to answer the complaint to 60 days from the date the waiver request was sent, as opposed to the normal 21 days. Waiving service does not waive the right to object to venue or jurisdiction. Interlocutory injunctions. Interlocutory injunctions are court orders requiring a person to do or cease doing a specific action before trial. Purpose is to prevent irreparable injury that will occur before the final judgment. Security. Movement must provide security that will be used to compensate defendant for damage caused by the injunction if plaintiff does not ultimately prevail. Preliminary injunctions. Traditional 4-part test. 1, irreparable injury, no adequate remedy at law. 2, reasonable likelihood of success on the merits. 3, balance of hardships. 4, public interest. Notice and hearing, required for the adverse party, appealable. Temporary restraining orders issued by the court when necessary to prevent immediate irreparable injury to a party. Not immediately appealable. Expiration, 14 days from issuance. Court may extend for good cause or with adequate or adverse party consent. If extended, temporary restraining order is treated as a preliminary injunction and thus becomes appealable. Notice to adverse party. Not required if moving party 1 shows immediate irreparable injury will result to her before adverse party can be heard in opposition, or 2, describes reasonable yet unsuccessful efforts made to give adverse party notice. Actual notice must have actual notice before they can be held in contempt of violation.